All right, Gabe Snyder and Nicole Patino are here answering all of our workplace and workers' comp questions. All right, so this person is saying, I work at a call center based in Florida. They didn't have a time clock for us to log in and out. Is that legal for a company? They're not keeping a record of the time that they work.
Well, they should be keeping record of the time that you work, and there's a difference between exempt and non-exempt employees. So depending on your position, you may be exempt from overtime or minimum wage, but if not, the company is required to keep a record of all time worked. If you are concerned that you're not being paid properly, keep your own calendar of times worked, keep some record of that, and then you can report that either to, well, this is a Florida company, but I'm assuming you work in North Carolina. You can report that to the United States Department of Labor, and they can help you with any unpaid minimum wage or overtime violations.
And usually when you go on the U.S. Department of Labor's like website or even Carolina, that kind of thing, it usually says file a claim or something of that nature, pretty big on the website. It's kind of decently easy to find.
Absolutely.
Okay. All right, Gabe, this person's asking, how long does a person have to file after a workplace injury?
Great question. You have 30 days. So there are some exceptions. The general rule is that you have to report it in writing to your employer within 30 days. There are some exceptions to that, such as when you tell someone, like a supervisor, that you were injured and they make a report, that's considered a writing. But to be extra careful, I encourage the person who's calling to report it either via email, text message, something in writing that they can point back to, and do so within 30 days of the injury.
30 days. Now, if you get hurt on the job, you're obviously going to go to the doctor, right? You're going to go to the doctor first, and then you're going to tell your employer, or, I mean...
Yeah, it's a good question. So there are cases where you're so injured that, say you get injured at the job and they take you via ambulance, you don't really have the opportunity to choose what you're doing. You're just following the instructions of doctors. That's okay. But the workers' comp, the employer and the insurance company workers' comp has the right to direct your medical treatment, which means you have to go to the doctors they tell you to. And so if you have an injury, you report it within 30 days, ask your HR representative at your employer, where do I go to the doctor? I need to go. And 9 times out of 10, your employer will have a place that they'll send you, like an urgent care, and you may need to push for a little bit more treatment, but they'll at least get you somewhere, hopefully.
Okay. All right, Nicole, this person's basically saying, what happens when you're falsely accused of something and then you're fired at work? Do you have any recourse?
Well, I would encourage you to call and talk to an attorney. In most cases, I would say no, unless there is some discrimination, harassment, retaliation, some underlying claim that you have. And a lot of times you do need to talk to an attorney to kind of suss out what that might be.
Okay, but someone can fire you for any reason
except what we call a bad reason, which would be unlawful discrimination, harassment, or violation of public policy of the state of North Carolina.
Okay, but they can say you came in late 3 times, I'm sorry, you're getting fired.
Absolutely.
All right. Gabe, I think we've got about a minute left. It says, at what point will an insurance company offer a settlement under workers' compensation?
Good question. So I'm going to start with beware of wolves in sheep's clothing. Okay. Sometimes a settlement being offered early is not such a good thing. I would say that they will usually start to offer it right when you reach maximum medical improvement, like I was talking about earlier. When we reach a peak or kind of a plateau in treatment, they'll usually try to get you to settle for a rating. Be careful. If you settle for a rating, then you are giving up your right to future temporary total disability benefits, which is the weekly checks that you get while you're out of work. At that point, you're making an election and maybe choosing the lesser form of compensation. So it should be a rare occasion, usually when you go back to work at the same employer, is the only time you take the PPD rating.
Gotcha. Okay. Thank you both for answering our questions today and helping us sort all of this out. If you missed any of this, what we want you to do is head to the WFMYnews2.com website and look in the 2 Wants to Know section.